All right, good morning, everyone. Thank you for joining us today. I appreciate you all being here and bearing with me through all of the confusion around Eventbrite and Zoom webinars. So thank you. I'm really excited about our presentation today. We've got Nick Allen with us from Columbia Legal Services, and we are going to be talking about legal financial obligations. So I'm excited to get going with that. Before we get started, I would love to ask if you could all introduce yourselves in the chat with your name, pronouns, organization and role, and email address if you'd like to share it. That way we can see who's here and connect. And then I'll just take one moment to introduce myself and then we'll get started. So if I haven't had a chance to meet you yet, my name is Jennifer Quiroz and I am the Executive Director of the Financial Empowerment Network. I just started in July and many of you may have known Alice Cody, who retired. My background is in nonprofit programming, which I've done for over 20 years. And most of that time has been in gender-based violence and here in South King County. But I got into financial empowerment through teaching financial education to survivors of domestic violence. And then that led to managing multiple financial empowerment programs with the YWCA. I stepped back from that in 2016, but I'm really excited to be back here and connecting with all of you. And so my philosophy is really that I'm here for all of you. I see the network as a convener and connector. We are a coalition. So if there are ways that I can support you in your work, if there are workshops that you're interested in or folks that you would like to meet, please reach out. I would love to get you connected and I would love to meet all of you if I haven't had a chance to do so yet. All right, and thanks to those of you who are dropping your information in the chat. So I'm going to stop sharing now and I am going to turn it over to Nick. Thank you so much, Nick, for being with us here today.
Jennifer mentioned, my name is Nick Allen. I'm an attorney with Columbia Legal Services. We're a statewide civil legal aid provider here in Washington State. We've got 5 offices across Washington. I'm in the Seattle office, but we also have offices in Olympia and Kennewick, Wenatchee, and Yakima. We've really got 2 focus areas of work. One is on ending mass incarceration. One is on promoting immigrant equity. I'm responsible for the ending mass incarceration work. And as part of that, what we've done for as long as I've been at CLS is really focused generally in 3 areas of work. One is conditions-related work in institutions around the state of Washington. We've done a lot of work to advocate on behalf of juveniles in the criminal justice system, and then also reentry work. And that's kind of where our work around legal financial obligations has started. It is a major reentry issue, as will be discussed here today. And we think it's important for reforms to be had around legal financial obligations so that they are not having the negative impact that on people entering and coming out of our criminal legal system. Here's a little bit of today's agenda. I'll talk for about 30 or 40 minutes here, giving you an introduction to legal financial obligations, talking about the laws and how they impact successful community reentry and financial stability in Washington State for people who are ordered to pay them, and then talk a little bit about addressing LFOs and answer any questions that you might have. Please feel free to just chime in if you do have any questions as we go through here. I want to make sure that I'm giving you the information that you want, and that can be, best accomplished by just shooting a question into the chat box, and if Jennifer just flags that, I can answer it at that time. So what are LFOs? Good starting point. Here's the statutory definition. It's kind of long and convoluted, but all you need to know is that legal financial obligations are court-ordered monetary sanctions. They are imposed as the result of a criminal conviction in Washington State. And they are imposed in all courts, so municipal courts, district courts, and superior courts in Washington, so all levels, and they're imposed for all offenses. So that means you can get legal financial obligations for everything from the most low level of misdemeanor all the way up to the most serious of felonies. So nobody who's coming through the criminal legal system really can escape the reach of legal financial obligations. I think this is important to know that legal financial obligations really fall into, I think, 3 buckets. That is important because it can determine whether the court can impose these type of obligations and whether or not you can get relief from them later down the line if they are imposed. And those types are fees, costs, assessments, kind of all lumped together, fines, and restitution. And I'll describe the differences between each one of those in this next slide here. As you can see, fees and costs you can think of as user fees. These are the costs that the state incurs as a result of, arresting, prosecuting, convicting an individual who's charged with an offense in Washington. And they're mostly discretionary, as are most legal financial obligations at this point in time. But can be really burdensome. You think about the various different costs of recoupment that can be imposed. One of the more common ones is people are charged for the cost of their public defender quite often. You always hear that if you cannot afford an attorney, one will be provided for you. It's your constitutional right, but they don't tell you that you can later be charged for the cost of that public defender. When you're talking about fines, you're talking about LFOs that are imposed strictly for the purpose of punishment. So you are convicted of an offense, and as one of the means of punishment, the court can impose a fine, either generally or offense specific. Sometimes there are some fines that are offense specific that the court can impose, and those are also mostly discretionary with some with few exceptions. And then you have restitution, and that is, of course, victim compensation, amounts that the defendant is ordered to pay to make the victim whole. That is mandatory in our state superior courts, or courts of general jurisdiction, where there is injury to a person or damage to property. In our courts of limited jurisdiction, our municipal and district courts, restitution is discretionary. And here, just over the next 3 or 4 slides, it'll really show you the breadth of LFOs in Washington. And this is just a small sample of the different types of LFOs that can be imposed in Washington state. Again, some mandatory, some discretionary, some conditionally mandatory, really all over the place. Gives the court, in some circumstances, a really broad menu of options that can be imposed upon somebody who's been convicted of an offense. What about other debts? Oftentimes I find that it is sometimes even more helpful to know what LFOs are not than it is to know what they are, because there's a lot of misinformation or misunderstanding about legal financial obligations. And the reason that occurs is because, I showed you our statutory definition, which is, really specific and specific to Washington state. But on a national level, the term legal financial obligation has really, in some circles encompassed a broader range of debt that is imposed by the court. And sometimes, we'll get calls, we'll get correspondence from folks that'll say, I have legal financial obligation. Can you provide assistance with this? And oftentimes have to say, no, that's not, can't do that because that's not a legal financial obligation. These are governed by other laws. And some of those include, civil infractions. So parking ticket, a speeding ticket, those are infractions, and those are governed by a different set of law, even though they can financially have similar impacts to legal financial obligations on the person who receives them. Similarly, consumer debts, these fall outside of the scope of legal financial obligations, and again, are governed by a different statutory scheme. And finally, child support. It's interesting, oftentimes we'll get calls, and this is not happened as regularly as education efforts have taken place, but sometimes folks think that the child support is a legal financial obligation. But keep in mind, none of these debts generate from a criminal conviction, and so they're not legal financial obligations as defined in Washington State. So imposition and payment of legal financial obligations. There's really, once the conviction happens, the LFO train starts to move. And these are the three places where LFOs can be imposed in general. By the court at sentencing. So once a person is convicted, then, either sometimes that same day, other times sentencing will be put out a couple of weeks, but the court will generally impose most legal financial obligations, at least those non-restitution ones that I described earlier, the costs, the fees, the fines, at sentencing. Restitution can also be imposed at sentencing, but there is under statute an allowance that restitution can be imposed also within 180 days of sentencing. So sometimes you'll see a person who's already been transferred into the custody of the Department of Corrections will have their restitution hearing 6 months, up to 6 months after they've been sentenced. And then the other time is following an appeal. And I'll talk about these appellate costs a little bit later, but if a person files an appeal to their criminal case and is unsuccessful, they can be ordered to pay costs associated with their appeal. Actual collection doesn't begin until a person is released, as I'll talk about later. But while a person is in the custody of the Department of Corrections in one of the state prisons, deductions already start to take place. And the way this happens is DOC has a deduction matrix, and they take out monies for funds from various monies received by the person in prison, or wages that are earned on jobs that people are working in the prison. And for legal financial obligations, generally that's about 20% off the top. It's important to keep in mind that that's a large chunk of money for two reasons. One, individuals are not earning significant wages while in prison, sometimes as low as 30-40 cents an hour, and then on top of that, folks are not necessarily, there's other deductions that are being made by the department, and so you can end up seeing somebody who makes $100 over the course of a couple of months get 65-75% of those monies deducted because of laws requiring DOC to make those deductions. And here I'll show you, this is kind of gives you an example of all the different deductions that can be made from wages and other monies received from the outside that can reduce a person's earning capacity while in prison pretty significantly. So after release, things change. No longer are deductions occurring. If a person has a job or is receiving monies, they are personally responsible for making payments to the clerk's office for whatever, wherever the courts are where the person has the LFOs where they're imposed. So if the King County Superior Court, I have a conviction there, and the court imposes $500 in legal financial obligations, I then have to make payments each month to the King County Superior Court Clerk's Office. And I'll talk about some exceptions to that, but generally that's how it's going to work. And how much does somebody have to pay? Well, generally it's supposed to be reflective of their current ability to pay. So, if I have $10 in disposable income at the end of the month after I'm done paying for all of my basic living expenses, then I should be paying no more than $10 a month towards my legal financial obligations. In order to make this assessment, the clerk's offices oftentimes will reach out to an individual to meet with them. So they have to submit annual information to assess where their finances are at and set a monthly payment schedule. And this can vary widely from county to county on how this is done and how rigid, how appropriate the payment schedule will actually be set. You know, I've seen in some circumstances a person has very limited disposable income, but has been ordered to make payments of $100, $200, $300 a month, really setting that person up for failure. We do have, however, have some case law that's beginning to set some parameters around when a person can be ordered to make payments on their legal financial obligations. So where we're at now is, while it's not a constitutional violation to impose the legal financial obligations, it is a violation of the Social Security anti-attachment provision to order someone to make payments if their sole source of income is Social Security disability. And we have this case that I listed here, City of Richland v. Wakefield from 2016, that makes that the case. So if you are working with folks whose sole source of income is Social Security disability, and I would argue similar means tested public assistance, you can make the argument that no payments can be made until that there's a change in financial circumstances. And it's a little bit different in courts of limited jurisdiction, same idea. So if you've got that municipal court debt, that district court LFO debt, usually you're going to have to make a lump sum payment within a specific specified time period, say 30 days or so. And if that does not happen, then you have to enter into what's known as a time payment agreement with a private third-party entity. And this is problematic. You know, you would think that the higher level of offenses, there would be higher level of LFOs and more issues associated with it. But sometimes you see even more substantial problems in the lower courts for reasons like this. When you enter into a time payment agreement, and I'll show in the next slide, you're not just paying the principal amount that's owed on that debt. These entities add in additional costs, surcharges, and the like. That can really increase the debt significantly over a period of time. And then the other thing is that, you know, in both superior courts and courts of limited jurisdiction, these accounts can be turned over to collections. Sometimes you will see in some jurisdictions almost an exclusive use of collection agencies to collect the debt. While in other jurisdictions, you will see the court will collect it for a period of time. If that individual fails to pay or is not otherwise made payment arrangements, it will be turned over to collections, which of course, like the time payment agreement, creates a whole new host of problems and payment difficulties. The other thing is that non-payment can result in additional punishment and other adverse outcomes. I'll talk about this a little bit later, but this can include jail time for failure to pay, garnishment, and other wage and other property seizure mechanisms. It can there's a lot of different ways and consequences of non-payment that can impact somebody's life for with regards to legal financial obligations. Here's the time payment example that I was talking about. So this is a standard agreement with an entity called Signal Management Services. So say I get you know, $10,000 in legal financial obligations, and I can't pay that off over the course of a month directly to the court. Then I enter into this, but off the top, I'm going to have to pay a $15 setup fee. As you can see here, and this is true of the collection agencies and the time payment agreements generally, is that you're not going to have an amount that's generally reflective of your ability to pay. Instead, it's going to usually be a percentage of the outstanding balance or a set amount. So you can see here, if under $10,000, you're going to have to pay the greater of 10% of the minimum or $25. And then just if it's over in my $10,000 example, I would just have to pay 5% of $10,000 each month. And then you see even more costs are added on to this. So in addition to $15, you're going to have a a fee that is based on how many cases you have outstanding that you're going to have to pay each month. And then also that's going to differ whether or not your account is in current or past due status. If you're going to pay with a credit card or a debit card, that's going to come with a $3 fee as well. Keeping in mind, some of these amounts may not seem like a lot to all of us, but if you don't have anything to start with, this might as well be $200 a month or $500 a month, because for somebody with very limited funds, this is extremely problematic and creates a lot of stress and problems. Generally, in addition to what I've already stated here, historically, Washington State has been identified as having a particularly problematic and flawed LFO system. One that, as the two bullet points here show, punishes poverty, and as a result serves as a really major barrier to successful community reentry. And while there have been some changes, which I'll talk about here in a second, historically these problems have included a combination of, are caused by a combination of these factors. One is poverty, the general financial circumstances of people who are both entering our criminal legal system and then exiting. And there's a statistic, that, and this has been pretty consistent over the last, 20 or 30 years, and that is, that about 80 to 90, maybe even higher than that, % of people who are charged with criminal offenses in superior courts qualify for indigent defense. What does that mean? Well, that means that their income is, at or below 125% of the federal poverty guidelines, or they're receiving some kind of public assistance, etc. And so you're talking about a population that is largely unable to take on new debts from the start as they enter the system. Then you add to that a criminal conviction, which creates all kinds of barriers to employment and other opportunities, coupled with the poverty issue. And you have a recipe for disaster when the person is coming out. Particularly the higher, especially the higher the legal financial obligation is that's been imposed by the court. And then you combine that with really a scheme that is filled with unjust LFO laws. And I'll go through each of these examples here and give you some background on these. So we have mandatory legal financial obligations in Washington State. And what that means is that the court is completely divested of any discretion to consider ability to pay. And determine, based on that, whether or not the LFO will be imposed. Up until a few years ago, when the law was changed, everybody who was coming through a Washington State Superior Court was going to receive $800 in mandatory legal financial obligations. A victim penalty assessment, which is $500, regardless of if your offense included a victim or not, everybody gets that. A $200 criminal filing fee. Everybody gets that, and a $100 DNA collection fee. So $800 off the top without any consideration of ability to pay. And then when you move along to considerations of ability to pay, really broad, vague standards around what that means, leading to wide interpretations and across the state of what that means. So even in statutes where a court is required to determine ability to pay before imposing a legal financial obligation, that could differ from court to court. One court might say, well, this person is receiving means-tested public assistance, and that's enough for me to say that this person does not have the ability to pay. Another court might say, well, what if this person wins the lottery down the line? I have to account for that, and so I'm going to impose some legal financial obligations. Or, there's an example from a case a little over 10 years ago where the court found that somebody had the ability to pay and willfully had failed to pay their legal financial obligations because this person was homeless, but the court said they could have picked up cans. They could have gone out in the street and picked up cans in order to pay their legal financial obligations. So really wide variances as to what the definition of ability to pay is, even though we have that standard on the books. Interest penalties. have also been consistently one of the more problematic issues with legal financial obligations in Washington. Used to be up until very recently that interest accrued on all LFOs at 12% simple interest from the date of judgment until the LFOs were paid in full. And that includes both non-restitution obligations and restitution obligations. What that means is that folks who were going into prison were saddled with a pretty horrible set of circumstances. What we would see regularly is an individual would go in with maybe $1,000 or $2,000 in debt, come out several years later, and that amount has, doubled, tripled, or quadrupled. Or they would make payments towards those LFOs where the interest had accrued at an amount that didn't keep pace with the interest rate, meaning that even though they were making their best efforts to pay off their LFOs, there would be an increase in the total amount outstanding at the end of the day. Sanctions for non-payment, I talked about this a little bit earlier, but individuals who fail to pay can be incarcerated if their failure to pay is found to be willful. Well, like the ability to pay standard, we've also run into problems with the willfulness standard, where there's wide interpretations of what willfulness means. And so that, in some situations, I remember some work and investigation several years back now, but in some counties you would see, 40, 50% of people who are sitting in the county jail, most of them indigent, most of them folks who we would all agree didn't have any ability to pay LFOs, sitting in jail, sitting out their fees and fines. The court's jurisdiction to collect has been another problem traditionally. It used to be the case that the court's jurisdiction to collect would expire after a certain amount of years, like civil debts. But the law changed in the early 2000s, where the court's jurisdiction to collect over LFOs imposed for felony offenses never expires, runs indefinitely. So what oftentimes happens is that you will see individuals who have not committed any new criminal law offenses in 20, 30 years, who are still subject to possible sanction, who still owe these debts way, way, way down the line up until this present day. Added fees and costs, I talked about this a little bit. That usually comes through transfer to a collection agency or entering into these time payment agreements, which in addition to the interest penalties, really you can watch this debt just add up over time. Restitution is another issue. It's something that really has not been addressed much in Washington. Like I mentioned, it is a legal financial obligation. Oftentimes it'll be the most significant of the legal financial obligations. It can be very difficult to get out from under restitution. Really no ways to request a waiver of either the principal or the interest on the restitution, as I may have time to talk about that a little bit later. And then also these direct and indirect collateral consequences. Can't vacate your record if you have outstanding legal financial obligations, even if you've completed all other conditions of sentence, even if you have shown that you're, completely rehabilitated. The financial aspect can hold you back from being able to vacate, which can open doors to employment opportunities and other opportunities that are impeded by the existence of the criminal conviction. Voting, although this has changed, it used for the longest time, you couldn't get your full voting rights restored until you had paid off legal financial obligations. So really stopping or limiting somebody's civic re-involvement in the community after a felony conviction. The law was recently changed this past year. There was a bill, House Bill 1078, which makes it now so that there's full voting rights are restored once a person's no longer serving a period of total confinement. And then credit as well. This hasn't been something that I've gotten too deep into because oftentimes the clients that we have are not, the credit issue is the last thing on their mind, but have seen situations where credit has been affected by legal financial obligations. It'll show up as a judgment owed to Washington State, and I've actually seen people who have been denied housing. One example I recall was somebody was denied senior housing because they had these outstanding judgments on their credit history. Recent law changes, however, have moved us in a better direction. There was a comprehensive LFO bill that was signed into law back in 2018, House Bill 1783, and it did 4 or 5 things that move us in the right direction with regards to LFOs. And that's not to say that Washington is not still a state that has significant flaws with regards to LFOs. But I think through education and outreach efforts, there's been some improvements in the law. One of which has been eliminating the interest rate on non-restitution LFOs. So as of this effective date, June 7th of 2018, interest no longer accrues on those costs, those fees, those assessments, those fines. It only accrues now on restitution. The legislature also reduced the number of mandatory LFOs. So remember I told you about those $800 in LFOs that everybody would get coming through a Washington State Superior Court. Now it's just one, and it's the $500 victim penalty assessment. The criminal filing fee is conditionally mandatory if you meet the standard of indigence that has been set in statute. The court cannot impose that criminal filing fee at sentencing. The DNA collection fee is more, I guess I call it a more logical LFO at this point, because it used to be that you would get a DNA collection fee upon every conviction. Now I think the recognition is that your DNA does not change, and so why should you be charged for every a DNA fee for every conviction? Now you get one fee once your DNA has been collected. The DNA fee cannot be imposed again. 1783 also included some standards, some provisions allowing for conversion to community service of some LFOs. Now this is not expansive, and I also would say we could have a whole discussion for another day about community service and whether or not it is a impactful and appropriate way to use legal financial obligation collection. But there are, I think it is appropriate in some circumstances, and those options have been expanded in some regards. And then the standards for indigence, ad imposition and collection, talked about that wide range of standards and definitions that are used for ability to pay and willfulness. Well, now we have some limits on what that means with regards to both of those terms. Doesn't mean that there's still not some discretion that can be used there, but far more limited than it was beforehand. And then the last thing, there was a victim restitution priority provision in that bill, because victims were not getting paid out first when LFO payments were getting sent in. Oftentimes clerks would keep collection fees first, or would pay themselves the costs, the fees, the fines before it would go to victims owed restitution. And 1783 laid out the order of distribution for LFOs, prioritizing victims. Here's just a quick slide that tells you about some of the law changes that I've just described. I think I've covered most of these, but just gives you a visual of kind of some of the major changes to some of the LFOs. And like you'll see here, the victim penalty assessment is the only one that was not changed substantively. Here's a slide about the indigent standard. Pulls from the same statute that allows for assessing appointment of a public defense, and now is also used at least partially in the LFO context. Subsections A through C are used to determine whether or not somebody is indigent when determining whether or not LFOs will be imposed or sanctions will be imposed. There's always ongoing issues with ability to pay, and one of the problems is that there is no constitutional duty to consider ability to pay at sentencing. And so what that means is that really the only way you're going to be able to consider this ability to pay at sentencing is if it's statutorily required. And it's a big issue too, because once the LFO is imposed, although there may be some relief options at the end of the after they're imposed, they can be difficult to obtain. And we can make this a much more efficient system if we were looking early on at ability to pay and thinking not only about that individual as they appear before the court that day, but also where we want them to be once their sentence has been served, which I think most of us would say is better. They're better served, both the community and the individual with the conviction, if we're setting them up for successful reintegration back into the community. But as I said, most LFOs are discretionary, meaning the court does not have to impose them. And we've had some good case law here in Washington State, one of the cases being State v. Blazina, where courts have to conduct an individualized inquiry on the record into the defendant's ability to pay, but we're only talking about costs there. We're not talking about fines, we're not talking about restitution, we're not talking about any other LFOs, we're not talking about mandatories for sure. So under those circumstances, we still have some ways to go with regards to ability to pay for other LFOs. Like I mentioned, limited relief options are available under statute, for both discretionary costs and appellate costs. An individual can seek what's known as remission, which is just really another term for waiver after they've been imposed. But they have to show that they've been released from total confinement on the conviction for which the LFOs were imposed, that the LFOs, these costs create a manifest hardship for them. And then even under those circumstances, the court's not required to waive them. The court still has discretion to keep those obligations in place. It's really just an ask with no guarantee of relief. Appellate costs, like I mentioned earlier, can be imposed, and oftentimes these are really significant amounts. I've seen upwards of $10,000 in appellate costs being imposed on an individual who's lost their appeal. Until recently, we had some changes to the rules of appellate procedure. Once the state made a request for those costs upon an unfavorable decision for the appellant, they had to be awarded. So there was no consideration of ability to pay there. With a change in the RAPs, there's actually been a pretty positive development where the court now has to consider ability to pay in determining whether or not those appellate costs are going to be awarded to the state. But really, outside of costs, difficult to get relief. Other principal amounts, there's not a lot of available options for relief. You're not going to be able to get rid of most principles and fines, principles and restitution, and that's something that needs additional work. Interest, like I mentioned, from the effective date does not accrue on non-restitution, but it does still remain in place for restitution. And interest that was available up until the effective date on non-restitution also remains in place. You can file a motion to get rid of that interest. And it's actually one of the easier motions to file, I think, in Washington State, because the court actually has no discretion on granting or denying that motion. It has to grant it once you file the motion. So a positive development there. But with restitution interest, really not a lot of options. You have to pay off the principal before you can even ask for any kind of reduction in restitution interest. And the higher amount of restitution, the more that becomes an impossibility. I've seen folks with $750,000 in restitution that's owed, that's accruing 12% interest. They really have no expectation, no possibility of ever seeing that interest accrue. It's just going to continue to rise for the rest of their lives. And like I mentioned, there are some conversion opportunities under statute to community service, but still quite limited for the most part. I think this is important, and it's something that is always hanging over someone's head, particularly if they are indigent, if they lack the ability to pay, and have not been paying. Because as I mentioned, failure to pay can result in issuance of a warrant, arrest, and jail time. Really can disrupt an individual's life, even if at the end of the line the court says, well, I find that you did not willfully fail to pay, go back. You're no longer going to be in custody, but at that point, oftentimes someone will have lost their job. Someone will have, just again had their life disrupted while all of this gets sorted out. And failure to pay can also, like I said, there's really 4 options here for the court to use to compel payment of LFOs. One is garnishment, and then they have these 3 really LFO specific mechanisms that are provided for in statute: orders to withhold and deliver property, orders of payroll deduction, and wage assignments. All kind of work similarly, and I would put them kind of under the wage garnishment umbrella. And we see this happen for the working poor, folks who either just got a new job, folks who are have a job and can only pay their basic living expenses. Oftentimes you will see these mechanisms used as an alternative to jail, because it's a way for the state to get their money, whereas jail, they're not getting any money. It's sitting out fines or doing dead time, and nobody's getting paid the LFOs. So actually, in some respects, the garnishment is really devastating. Accessing relief, I'll just, if you know individuals who have legal financial obligations and they're trying to address their LFOs, this is really where you want to start. The questions that you want to ask: who ordered the LFOs, and do you have the proper documentation? And what kind of relief are you seeking? Because that can take you down different routes. Is it about interest? Is it about getting principal waived? Are you trying to avoid punishment for failure to pay? Are you trying to remove account from collections, which is something that is possible because the contracts with the collection agencies don't amount to a true assignment. It's really just giving the collection, it's contracting with a collection agency for them to handle the collection responsibility. The jurisdiction still lies with the court over those accounts. Knowing where you have LFOs is important. Lots of different disparities, as I mentioned, in practices. So in one county, you might be at a significant risk of facing arrest for failure to pay, while in other ones you might not. And so that could help you to prioritize how to deal with legal financial obligations. Here's some of the things that you would want to look for. I think these four or five documents really are going to be the base starting point, and most of these can be, well, all of them can be obtained through the county clerk's office in the county where the LFOs are owed: a JNS, an order setting restitution, any LFO related correspondence, and an order setting extending jurisdiction. The other thing that you'd want to look for is a case accounting or a case financial history, so that you know all of the details around the account, which is going to be important if you're going to be filing a motion for the court. You have to have accurate and verifiable data in there. Next steps. So like I said, 1783 was just a first step, and there's a lot of work to be done. We shouldn't think that 1783 solved all these problems. Still a lot of people, particularly those who are living in poverty and disproportionately communities of color, that are facing significant and severe impacts from LFOs. The problem has not gone away. And here are some of the issues that we need, I think, to continue to address address LFOs overall in Washington State. There were things that were left out of 1783. We've learned new things from our client communities and from legal colleagues about what else needs to be done. And this is really the menu of options, jumping into really examining restitution and restitution interest, further expanding the definition of indigence, providing some clear guidance on waiver of fines so that there's opportunities under the law to waive both costs and fines. Addressing this victim penalty assessment, addressing the mandatory nature of it, and giving people the option after the fact to go back and ask for mercy. Whereas right now there's no option to do that. You just have it in place. It's not uncommon to see somebody who's got 4 or 5 or 6 convictions with $500 each on those, $3,000 as a result in just victim penalty assessment monies, where they can't go back and ever ask for any relief. And then also limiting the court's jurisdiction to collect. The door has been open to do this examination. Right now, the legislature has a criminal justice sentencing task force, and LFOs are a part of sentencing and has been included in that discussion. There were recommendations that came out of that sentencing task force that address each of these bullet points that are listed here, and they were packaged into an omnibus bill. It was introduced as House Bill 1412 last year, got some movement, did not pass, so it died, but it'll be back this year. A companion was also introduced after the legislative cutoff that is identical to 1412. And so if you're interested in this issue, if you want to get involved in highlighting really how significant a financial problem this is, and what a major impact it is on successful community reentry for individuals with criminal records, this is what you would look to, and I'd be happy to provide anyone more information about this bill and the work being done around it. So I'm going to wrap up here, but I think it's just important to keep this in mind. LFOs, major barrier to successful reentry and financial stability. And just beyond the criminal context, just generally in people's lives, LFOs are very problematic. We have to continue to identify ways to eliminate their impact through all these mechanisms. And I would actually say that last bullet point, very important, community action, having discussions like this around LFOs, increasing education and outreach around these. But courts, legislature, research, and media, important as well. And please reach out to me if you have any questions or need more information or are interested in getting involved in these efforts. Here's my contact information. Thanks again, Jennifer, for the invite. I'd be happy to answer any questions now or offline.
Great. Thank you so much, Nick. This was so much information. I have a couple of things. I just put a link in the chat for a survey for today. So if you could please take a moment, we're going to do a quick Q&A and some announcements from the network. But if you don't mind working on that survey while we do so, it's helpful for us to gather information as a nonprofit to be able to report to our funders and also to hear from you about how this training went for you and ideas you have for future training. So thank you for taking a few minutes to do that. And there is a question in the chat, Nick, about LFOs and if they are for felonies only or misdemeanors or for both.
For both. So yeah, there's LFOs that are imposed for all levels of offenses. The types of LFOs can differ depending on whether it's a misdemeanor or a felony offense, but you can get them for both. And like I mentioned, sometimes you'll actually see higher amounts of LFOs for misdemeanors than you will for felonies for any variety of reasons.
Great, thank you. And if folks have more questions, please pop them in the chat. Okay, so there's another question. Do LFOs show up when opening bank accounts? So not necessarily, it says, I know they do for loans as I've seen them, but what about when someone's opening a bank account and they might be running like check systems?
That I'm not sure of. That's a great question. This is something that has never come up. I've never had a conversation with someone who said they were trying to open a bank account and the LFO showed up. If anyone on this call has the answer to that, I'd be interested, because yeah, I think it's about identifying as many barriers as possible. And if that's the case, that would be another significant one.
So Becky said convictions will not, however, if LFOs are in collection, they could. Thank you for that, Becky. I have a question for you, Nick. You mentioned debt time, that folks are sitting out time in jail. If someone is sentenced to jail for failure to pay an LFO, does that reduce the principal on their LFO?
It depends. So it depends on if it is through the Superior Court or through a court of limited jurisdiction. If you are convicted in the Superior Court and have LFOs from a felony offense, then that monthly payment is a condition of sentence. And as a condition of sentence, if you fail to pay, it's a violation of that condition of sentence. If you're then found to have willfully failed to pay, you can be ordered to serve up to 60 days in the county jail for that violation. That's dead time. So if you went in with $500, you come out with $500 owing. If you are convicted in a court of limited jurisdiction, then you would be in a contempt of court for failing to pay. Same theory, willfully fail to pay, and then you would sit out your time again in the county jail, but you would get credit for each day served, which is set by the county commissioners in most counties, and sometimes can be $50 a day. Other places it'll vary. Now, sometimes folks will say I'm good to sit out my fines, but it'll be individuals that I would say, no, you should have never been found to have willfully failed to pay in the first place. So I'd say there's some constitutional violations there, but yes, you would earn time under the contempt theory.
So complicated. Thank you for that, Nick. I do want to, if you have more questions, please put them in the chat, but I do want to just share a couple of things, announcements and updates from the network before we go in our last few minutes. As I said, please fill out the survey. And for those of you who have not heard, our Bank on Washington virtual forum registration is open. We're very, very excited. We have a great lineup of speakers, and we're going to be thinking about fintech and how it affects folks that are low to moderate income, unbanked or underbanked, and historically marginalized. So really thinking about the ways that technology can increase access, but then at what cost? Is it predatory access, or is it really access that's going to help folks improve their financial wellness? And then who is still excluded from this, and what does that look like? What is research telling us about it? So join us, and I'll drop the link in the chat as well. You can learn more at bankonwashington.org. We have a couple of other workshops coming up from the Financial Empowerment Network on September 30th, child tax credits and updates on tax preparation from this last year and what's coming up for 2022. And that's with Williette McKinney-Farrell from the IRS and Terrence and Larry from the United Way. And then in November, we're going to be doing a deeper dive into consumer debt and collection issues with Julia Kellison from Northwest Justice Project. And there's more information available on our site at everyoneiswelcome.org. Also, we have a Bank on Washington Facebook page, so please join us there. And then, as I said, our site is bankonwashington.org.